The United Kingdom of Great Britain and Northern Ireland is the only European country without a single document constitution. This does not mean, however, that there are no written constitutional sources. These include the existing statutory provisions, traditional conventions, and accepted statement of constitutional principles. Of particular historical importance are the Magna Carta of 1215, to which the exercise of political power is bound by law. Then there is the Petition of Rights of 1628, which made tax collection conditional on the consent of Parliament and guaranteed protection against arbitrary arrest. And the Habeas Corpus Law of 1679, also interpreted today as a statute protecting against imprisonment without trial. The substance of the British Constitution can be traced back to two principles: the rule of law, which means that state action is bound by the law, and parliamentary sovereignty. The rule of law protects citizens from arbitrary actions by the state and forces Parliament to give legislative form to the transfer of powers to the government. Laws can be repealed or changed by a simple majority in Parliament. Special majorities to change the constitution are not necessary because there is no constitutional document. What they call constitutional reality, as it is reflected in the state of legislation, can be changed quickly and flexibly. The practice of flexible constitutional development is simplified by the English legal tradition. It is based on common law. The main feature of the common law tradition is the orientation of case law on precedents, that means on model decisions that can be used to decide new disputes and that can be further developed by the new legislation. The starting point for legal decisions is always the specific case and not a general rule. There is no legal code such as the German Civil Code, for example, our BGB. The Scottish common law tradition differs from the English one in that, in addition to elements of the English law, it is based on continental European Roman legal traditions, the continued validity of which Scotland was guaranteed in 1707 when it united with England. The second cornerstone of the British Constitution, in addition to binding state action to laws, is parliamentary sovereignty. The Parliament passes the laws and controls the legislation alone, but is not bound by an overriding constitutional text. Parliament, not the people, is the legislator. A constitutional court that could overturn parliamentary decisions does not exist and is unthinkable without a constitutional document. So it is up for the viewers now, like you, to decide which is better: a constitutional document like in most other countries, or not to have one like in Great Britain and the United Kingdom as a whole. And I'll see you in my next video. Bis gleich.